to have you on the other side of the radio as we push the conversations forward or take it a notch higher. Welcome. I am Kaladako Rubatibor. You're listening to Hard Facts and 92.3 Nigeria Info. Remember, you can follow me on social media, dKalada, TheKalada, or better still, you can watch us live on Facebook, on YouTube, or interact with us on X. Nigeria Info PH is the handle. All right, so it's time for us to have a topical conversation. And what best to talk about, if not the political situation in Rivers State? And my subject matter for the hour is the factionalized House of Assembly here in Rivers State. So as you already know, we've got the Martin Amaewhule led assembly, and they have an argument, legal argument, that hey, there is the Justice Omotosha's court ruling, there is the Court of Appeal ruling, we have the Victor Okujumbo led assembly, which is holding on to, I can't remember the name of the judge now, but yeah, there is the ruling that gave the interim injunction for Edison at the time to be speaker, wherein he declared the seats vacant. The Martin Amaewhule and other lawmakers, declared their seats vacant, and from there he left, and then Victor Okujumbo said to have taken over. So yeah, they all have legal arguments. I'm not the court. I will not make the decision. I will let the courts make the decision. However, what we're seeing is both factions sat for plenary today. We saw Victor Okujumbo led House of Assembly screen and confirm Emmanuel Frank Fubara as commissioner designate. We saw that plenary also looking into the River State Emergency Management Agency Bill 2024, and we saw that plenary look at the River State Transport Company Reform Bill 2024. But at the same time, we saw the Martin Amaewhule and others also issue a 7-day ultimatum to Governor Siminalayi Fubara to present the 2024 budget before them. Now, Mr. Amaewhule read a letter which they plan to send to the governor during that plenary at the State Assembly official quarters along Aba Road. So it's really getting interesting. They also barred the government, or rather I should say, the Rivers State Executive Government, from spending funds from the Consolidated Revenue Fund of the state. They accused the governor of breaching some sections of the 1999 Constitution and the Rivers State Local Government Amended Law 2023, among others. They said the governor's dealings with and recognition of the assembly made up of the said suspended lawmakers constitute gross misconduct and abuse of office. Now, when someone uses the word gross misconduct, more particularly if the person is the speaker or one of the speakers, it looks like there is an impeachment plot. I mean, that's what I understand. I'm not trying to raise any dust or any storm. But I do have with me via the phone a lawyer. He's been on the show before. And he predicted a while ago that the Court of Appeal may rule in this manner because according to him, in his interpretation of the Constitution, the State High Court does not have jurisdiction to try matters as it relates to the House of Assembly and the vacation of seats. So it's really going to be interesting. I have Godspower Egbule via the phone, is a lawyer, and is my guest today. Welcome, Godspower. It's good to have you.
Good evening, Mr. Kalada. It's always my pleasure to be on your show.
All right. So let's start from what happened last week on Thursday, I believe, if I remember vividly. What do you make of the Court of Appeal's judgment? Some people say, it's not victory yet. It's not victory for Martin Amaewhule and co. How are you seeing that argument?
Well, Mr. Kalada, I have always said this. I'm not a politician. I'm a lawyer. That's why I know that these political contestations have different parties that are affected. I would continue to say it's actually a victory for our constitutional democracy. It goes to show that irrespective of the high office that you hold, you must respect and abide by the provisions of the Constitution. Well, it's a victory day for the Martin Amaewhule House of Assembly, and I have always said that his leadership of the House of Assembly has never been disputed. He has been the Speaker of the Rivers State House of Assembly, and legally has never been removed. I've always had that opinion. And I've always said, you may not like him, but irrespective of whether you like him or not, you must accord him that constitutional privilege, and rights, and address him not as a factional speaker, but as a speaker of the Rivers State House of Assembly, because the Constitution does not contemplate factionalization of the House of Assembly. So he has every right to rejoice, and those who are affected by the judgment also have every right to express their reservations. The Constitution gives them the right to express opinion on issues like this, but irrespective of your opinion, irrespective of your emotions, the Constitution would always prevail.
Okay, so now you've said it's a constitutional victory for our state, but there is the issue of defection. Let's go back. Is it constitutional for one to defect as a lawmaker?
I have always held this opinion, and I stand by them, except as by any superior argument or court decision. I have said that if you take a look at the provisions of a constitution, you cannot say that by merely defecting, that a member of the House of Assembly loses its seat. I have said Section 109 has subparagraph 2. I do not know what people who think it is automatic want us to do with subsection 2 of Section 109. There are 2 limbs, actually 3. There is subsection 1, subsection 2, and subsection 3. Subsection 2 gives the speaker the sole power to declare seats vacant.
But yet again, but you see, the reason why I asked this question is because even the speaker has defected. So even if the Constitution gives him the power to, but he has also, let's say, defection is wrong, also defected, shouldn't his seat be declared vacant?
No, by who? Do not forget that one of the outcomes of the Court of Appeal judgment was that the express mention of one thing means the exclusion of the other. If the Constitution has declared and stipulated that the only person who can declare a seat vacant is the Speaker, until he does that, no other person has the right to declare the seat vacant.
Okay. All right. So, when you argue these things like this, one would wonder, okay, if that be the case, then why are we going back and forth? Because it has certain adverse implications on governance in Rivers State. Now that this judgment, is like this, and then the Victor Okojumbo is holding on to the fact that, okay, there was the interim injunction, and it was given. The court gave the right to Edison to be speaker, and Edison declared the seats vacant, and as such, it gave room for him to be speaker. What would you say to that as a lawyer?
Let me make some clarifications here. Number one, I have said that there is nothing in the order given by Honorable Justice Danagogo that declared Edison as a speaker. I have said so. And I was in your studio one day when we did an analysis of the different orders given by Honorable Justice Anagogo. In any case, there is a judgment, a valid, uncontested, unappealed judgment of Honorable Justice Omotosho. What did that judgment say? Hold on, I'm coming. That judgment nullified everything that Edison here did. It's a judgment of court, it's not been appealed. That judgment, for one, nullified the appropriation bill of Rivers State 2024. Meaning, as of today, Rivers State does not have an appropriation bill. The governor, not the Attorney General, has not appealed that judgment. So we do not have a budget of 2024 in Rivers State.
Okay.
So someone coming to tell you, Zanagogo granted an order declaring Edison as speaker. No court can grant an order declaring anybody.
Now, if I remember vividly, I do not know if it was Danagogo's court or not. Like I would always say, there are plethora of issues right now at the courts, at the various courts. I don't know if it was Danagogo, but there was the interim injunction giving, and it stopped Martin from being speaker. And in that process, Edison took over, and Edison declared. I think it also gave Edison. I remember also putting a fine of about. I can't remember how much fine, but it put a fine out there and said if Edison and co misled the court, then they would have to go in for it. However, after the expiration of that interim order, they went and they got another one to extend it by another 7 days. And after that, they withdrew the case. So if I remember vividly, there was something like that.
I have done an analysis of the order just to give you a background of the plethora of cases that have emanated as a result of the political imbroglio that we have in Rivers State.
Okay.
You have that of Honorable Justice Forowo. You have that of Honorable Justice Omotosho. You have that of Honorable Justice Danagogo. And you have that of Honorable Justice Wali. These are the 4 issues. That of Honorable Justice Danagogo did not declare anybody as speaker. And I did an analysis on your radio station. So you can't say on the basis of that order, someone can assume the speakership of the Rivers State House of Assembly. And I said that whoever is a speaker of the Rivers State House of Assembly is a constitutional matter provided by the Constitution. And so you must go through the procedure. If you have an elected speaker, there are conditions for you to remove that elected speaker. Certainly not by you declaring yourself as a speaker. It is not in the contemplation of a constitution that we should have factionalization in the House of Assembly.
So now that we have a faction, what does the Constitution say? We have 2 people claiming to be speakers of the House of Assembly, and 2 different houses of assembly. One sitting inside of Government House, the other sitting inside of the House of Assembly quarters. So I'm listening.
Let me just question very quickly. Imagine you, Canada, saying you're the governor of Rivers State. Expect anybody to take you serious? And another people is saying, "Oh, we have another factional governor of Rivers State." It's not possible. We must give things their name.
Okay.
Whoever you are, whatever position that you occupy, no other person can constitute himself or themselves as members of the Rivers State House of Assembly outside of the middle.
Godspower, we have a commercial. When we come back, we continue. Please do stay tuned.
Thank you.
Stay with us. This is your number one talk station. Nigeria Info. It's hard facts.
It is the bottom of the hour. Yes, you heard me right. You're listening to Hard Facts and 92.3 Nigeria Info. I am Kalada Koribatiba and I'm speaking with a lawyer, Godspower Egbule, and we're looking at the current situation, factional houses of assembly, or should I say, two houses of assembly in River State sat for plenary today, and we're looking at the legal implications. And, we're taking it from how it started and how we got to this point. And, my guest has been saying that looking back and looking at all the cases in court, there is no one that has actually said Martin Egbule cannot or is not the Speaker of the River State House of Assembly. So now we want to get into the legal implications. If indeed, what he argues is true, because both sides are arguing that they have some legal rights to the speakership or to being the rightful House of Assembly. And if one indeed is the wrong one, what is the legal implication? Welcome back, Godspower. Godspower, can you hear me?
I can hear you clearly.
Welcome back. Yeah, thank you very much. So, before there was and
Martin Egbule as the Speaker of the River State House of Assembly, and it is uncontested. And so, whether anybody or a group of persons decide to amalgamate and choose to operate under the name of the River State House of Assembly, it tells you one thing: it's an act of desperation, and the society should not take such a person serious. Ours is a constitutional democracy. I have said this, that even if the governor appears like he is a victim, he's actually the villain in all of this. And I hold that opinion. He's actually the villain. And so when you have this, the seat of a governor condescending to the point where you do not respect separation of power and independence of the legislature, I wonder what you want the society to think of you. Mr. Kalada, let me tell you, as far back as the Philadelphia Convention of 1776 that gave rise to the U.S. Constitution, go and check the U.S. Constitution, Article 1. The first thing it promulgated was the legislature. Was the legislature. The legislature remains a very important arm of government and a beacon of democracy. Sadly and unfortunately, we have a situation where the government of River State, represented by Governor Fubara, now wants to put the legislature in his pocket. He now determines how the River State House of Assembly should be constituted and to tell Rivers people who is the Speaker. It is a constitution that made provision and procedure for how the Speaker of the River State House of Assembly will be elected. And so all of these political chagrins, all of these political contestations show desperation on the political actors to just subvert the provisions of the Constitution. And I have always said it is a tragedy. It is not something we should condone. The legislature is the beacon of democracy. And if you take a look at what has been happening, there seems to be an orchestrated plan.
Okay, let me pause you now. So let's argue, conceding to your arguments, but not admitting that it's the right one. Let's just, for the sake of the conversation, concede that you're right. What then is the legal implication of, like someone would call it, cloning the authentic River State House of Assembly?
Simple. By virtue of a Court of Appeal decision delivered on the 4th of July, 2024, every other action taken against that subsisting court judgment is contempt of court.
Okay.
Simple. Contempt of court. And that's a criminal allegation. That's a criminal offense. It's contempt of court. You can't act against the ruling, the judgment of a superior court of record. Sometimes I wonder who advises the political actors that want to be in contempt of court? Because you still go back to that same court. You're in breach. You're in disrespect of the rulings of a court. You will still go back to that same court to get one for the other.
So now let's go back to Danagogo's court, because while I asked you that question, I was trying to do a quick research. Now, the suit number PHC slash 3030 slash CS slash 2023. In that suit, which has not been withdrawn, by the way, there was the ex parte motion, which granted Edison Eye the authority to what's the word now, to preside over plenary of the House of Assembly pending the determination of that case. Now, in that, the court barred Martin Ameule from being speak and in the seats of Martin.
It didn't happen. It did not happen. I'm saying there is nothing in the order granted by Honorable Justice Dana Gogo that empowered Edison Eye to act as a Speaker of the Rivers State House of Assembly. I mean, we did an extensive analysis of the order. None of the reliefs granted by that expert application said any other person other than Right Honorable Martin Ameule is the Speaker.
So are you saying an order of interim injunction restraining the defendants, whether by themselves, their agents, servants, privies, and representatives in whatsoever and howsoever manner, from preventing, disrupting, and interfering with the smooth and regular operation, management, and administration of the first claimant and applicant pending the hearing and determination of the motion or notice already filed in the suit. An order of interim injunction restraining the defendants, whether by themselves, their agents, servants, privies, and representatives in whatsoever and howsoever manner, from preventing, disrupting, and interfering with the exercise of the second claimant and applicant's statutory legislative duties of summoning and holding meetings, proceedings, issuing notices, passing resolutions, bills, and performing other legislative functions of the first claimant and applicant pending the hearing and determination of the motion on notice already filed on the suit. Yeah, I'm listening.
I have explained this particular relief to you, and I have said that is the relief for every member of the House of Assembly. That is a relief grantable to any member of the House of Assembly. Any member of the House of Assembly can exercise that relief, but the relief of who is a speaker,
okay,
is only determined by the Constitution. Every member of the House of Assembly can summon a committee meeting. Any member of the House of Assembly can do every other thing that you have read out in that particular relief. Is the Speaker of the House of Assembly, is the name the Speaker of the House of Assembly so big that the court couldn't have said, I hereby restrain Right Honorable Martin Ameule? I'm saying it's not in the contemplation of that ex parte order to say they declared any other person Speaker outside of Martin Ameule. It didn't. It only said, exercise your legislative functions. Every member of the House of Assembly can exercise that legislative functions, but not every member of the House of Assembly can exercise the functions of a speaker. I've made that commentary at times, that there is nothing in that order that empowers any other person outside of Right Honorable Martin Ameule to act as Speaker of the House of Assembly. In any case, everything done by a year, including in the passage of the budget of 2024, has been nullified by the judgment of Honorable Justice Omotosho. And that judgment is a consent judgment. And the parties involved understand the implications of a consent judgment. A consent judgment means that you admit to the facts of the case. It means that the parties in that suit admit to the fact that's presented by Right Honorable Martin Ameule. That's the meaning. You're not disputing anything. Do not forget that the governor is a party to that judgment. And here Edison withdrew his processes in that judgment. So all the parties consent to the facts. They agree, they approve to the facts as presented by Right Honorable Martin Ameule.
That's what it means by withdrawing. So they all agree to the arguments of Martin and Co.
But Edison that withdrew, but the governor is a party.
That's what I'm saying. So my point is, the withdrawal means that they agree, or whoever is withdrawing agrees to the arguments by Martin. Is that what you are saying?
Yes.
Okay. All right. Okay. So now you've said contempt of court. How then do we enforce contempt of court? Let's agree once again with the arguments you've made. How then do we enforce contempt of court?
The parties in the suits. Remember that the every judgment or ruling of the courts declines the rights and liabilities of the parties.
Please be audible. We can barely hear what you're saying.
Okay. Can you hear me now?
I can hear you. I can hear you now. Go ahead.
I said every ruling or judgment of a court declares the rights and liabilities of the parties that are involved. And so the parties that are involved in this suit, whose rights and liabilities have been determined, have the rights to approach the court to inform the court that a party is in contempt of the judgment and the rulings of the courts. But irrespective of that, is to all of us conscious must not give any legal validity to any assembly other than the assembly constituted and led by Right Honorable Martin Samehu.
Interesting. That's
on our own part as citizens. So even before the commencement of the contempt proceedings, we have a duty as citizens of the Federal Republic of Nigeria to make sure that we don't give validity, we don't give legitimacy or consent. And that's also why I always
when you say let me pause you. When you say we have a responsibility, how do we even have that responsibility in the first place?
My name is Godspower. I cannot call any other person the Speaker of the River State House of Assembly other than Right Honorable Martin Samehu.
Because you're entitled to your opinion. I mean, you have your opinion. Okay, all right.
Let me explain. It's not my opinion now. I mean, there's a subsisting Court of Appeal judgment on this issue. So after the Court of Appeal judgment on this issue, and nobody has appealed. I mean, you mean anybody can just wake up from anywhere and say, I'm the President of the Federal Republic of Nigeria. I am the governor. I am this, and this. I am saying that it is descent into anarchy. We're not a banana republic. It is not in the whims and caprice of the governor to dictate against the provisions of the constitution who the speaker is. And so, as private citizens, as corporate entities, if you do not recognize who is not recognized by law, it will not fly. So I'm saying we have a holistic constitutional duty not to give legitimacy to whom it is not given, it shouldn't be given to. And so you have somebody say, oh, the factional speaker, Mr. Kalad, and this is where every other person comes in.
I say the factional speaker, and I'm going to say it until the Supreme Court comes up, with a judgment. I believe it will.
Okay. Now let me ask you a question.
Yeah.
And so, if they do not appeal, what then happens?
No, they have appealed. They have gone to the Supreme Court. I think they did that on Friday. They have appealed and gone to the Supreme Court.
Have you seen the processes? Have you seen the processes?
They said they have appealed.
Yeah, they say they have, but can you just do a confirmation and reach out to them and ask them if they have? In any case, even if you appeal, you will still need to obey the substituting judgment of the other courts. And so, before the Supreme Court gives its final judgment on this issue, that's off the court. Okay. It is only the Supreme Court that can set it aside. Until then, every party must obey it.
So let's go back a step backwards. So, does this Court of Appeal judgment affect other states' high court judgments that are somewhat related but not exactly to this very matter?
Well, I may not appreciate what you mean if it is related, but I know that the state high courts, whether in Rivers State, Lagos, Adamawa, Abia, no state high court has the jurisdiction to determine whether the seat of a member of the House of Assembly has been declared vacant. None.
Okay.
And so, irrespective of states, it of binds, because it's actually the interpretation of the Constitution. So it binds every other state.
Okay. Let's go to the phone lines. Let's listen to what some Rivers people have got to say as it relates to this very matter. The numbers are the same: 0817 923 0002, 0817 923 0003, 0817 923 0007. All right. Let's get to hear your thoughts. So take the numbers again slowly this time. 0817-923-0002, 0817-923-0003, and 0817-923-0007. WhatsApp number 0809-030-6416. Let's go to the phone lines, and after that WhatsApp, and I read some messages on Facebook. All right, let's see what we'll have here. 92.3 Nigeria Info. What's your name? Oh my.
Yeah.
Hello, 92.3.
Hello.
Yeah, welcome. What's your name?
Yeah, my name is Taiwo, calling from Canada.
Your name is.
Question is to your lawyer is
Your name is Taiwo, you said.
Yes, Taiwo.
Oh, Taiwo.
Yes.
Taiwo, welcome.
Yeah. What I'm going to say is the Constitution section 109 that talks of vacating your seat if you defect. What are you to say about that?
Okay, section 109. I think we touched on that already, but when it comes, when it's time for him to speak, I'll let him touch on that one. 92.3 Nigeria Info. Yeah, good things to you. Please be audible. I can barely hear what you're saying.
Can you hear me, Canada?
I can hear you now. Go ahead, please.
Yes, my name is Comrade Kwate Magnus, and I'm calling from Port Harcourt.
All right, Mr. Magnus, welcome. What is on your mind?
I want to say that the political crisis in the state can be avoided if politicians begin to know that the interest of Rivers is paramount.
Okay.
Like I always said, when once you need to place your personal interest above the interest, it becomes a problem. And so I want to appeal to the graduates. It is important that Rivers people's interest is protected, no matter how it is, or no matter how you want to look at it. Rivers people's interest must be protected. The court, as you know, is a common hope. If we hope in the life of a common man, and as such, the court has spoken. Why can't we just obey the court and let peace reign in the state? It is very important. The governor should concentrate on governance. That is the sole reason why he is being elected as the governor of Rivers State. He needs to deliver the good governance to the people of Rivers State. So he shouldn't be distracted. Whatever is happening in the state today, I don't really know. But at the end of the day, it is the detriment of Rivers people, and it's not good.
All right. Thank you very much, Mr.
And we must free from peace. We need development in Rivers State. It is our state.
All right.
We now run from our state to another state. It is our state, and we need peace and development.
All right, Mr. Magnus, thank you very much. Quatem Magnus, I've got to go. 92.3 Nigeria Info. What's your name? Elder Wayamu, welcome. Let's get your thoughts, please.
Yes. The guest is from Ekiano. He's a brother and a friend. he knows my thoughts.
Let's leave that and get to the conversation, please.
Let me ask a question.
All right.
When governor has a matter and Nachikos, they said he has been disqualified. I'm not mentioning the governor. I want to cite maybe our ex-governor, Wike. When they said the court has appealed, sacked my governor, he remained there and appealed. If Supreme Court has said otherwise, or yes, has been sacked, he would have left. That time they said, appeal, said you have been sacked. He's no longer governor. When he appealed, he remained as governor until the termination of the Supreme Court. That's what I want to explain more, because if appeals said in favor of this or that, the person that was there should be there until, if we do not appeal, I think that we can answer that. But if they have appealed, if they appeal, they have to remain.
Elder, I think my own understanding is, if the state high court made a judgment, made a pronouncement, and then it was obeyed, then the court of appeal makes another pronouncement that contradicts what the state high court does. The higher court takes the day. So what is supposed to be will be that of the higher court, in my own opinion. That's what I think, but would listen to the lawyer.
Let me ask the next question, please.
All right.
The next question.
Quickly then.
The section, the barrister did not talk about whether these people actually defected or they did not, because it went viral that they have defected and become members of the APC. What is the stand if somebody has defected or because they went viral,
all right,
no longer members of CDP and this one? And what is the situation? What is the, let's explain their legal term. What does that mean? Okay.
All right, thank you very much. So Section 109, yet again, 2 questions for Section 109. Interesting. But let's quickly look at the Rabuchi's message. Rabuchi Kano, it's been a while. I do appreciate you commenting from England. He said, I want to inform you that your guest is railing out academic works, interpreting the ruling of courts the way it pleases him. Another lawyer will come to your studio and do the same. Remember the presentation of Imo Ugochiere. All I know is that the political class has failed Nigerians and will continue failing Nigerians. There is hunger in the land, but politicians and their families are smiling to the bank, yet they use frivolities to blindfold the suffering people. Until Nigerians wake up from their slumber, things will continue to go awry. Good afternoon once again. Thank you very much for that message. I do appreciate it. This one says, the position of your guest is very laughable. I hope he knows that Martin Ameule is a member of House of Assembly before he became a speaker. Did he think that Martin Ameule will ordinarily vacate his seat? And him still claiming that he is the speaker after defecting is a gross misconduct, which is its own an impeachable offense to him. Everybody should have kept quiet so that they will go on with that illegality. Mike from New Road. I do have this one. It says, Canada, good afternoon. Your guest initially said he's not a politician, but from his words, it obviously means he's a pro-Wike lawyer. We're watching from Christian. This one says, please ask your guest if Ameule will stand the position of declaring his seat vacant while he's among the DKMPs. I think his defection to APC grants another member of the House to preside over the activities of the House, or is he having that? Is he saying that if Ameule and co are axed out of the House by a court now, will the House be without a speaker? Victor from Egbule. Now, back to you. Barrister Egbule, some people are going back to Section 109 of the some people are going back to Section 109 of the Constitution. I don't have much time, so I'm going to let you answer their questions. You're saying if he defects, and I think I asked you that question, and even though the Constitution says, the Speaker will be the one to preside over the declaration of his seat vacant, but he also has defected. And if he has not defected the right way, it means he has also committed some kind of crime, and his seat should be vacant. So how do you explain that part of the whole confusion?
Okay, Mr. Kalada, quickly let me say that I have always held this opinion by which I stand that as the constitutional democracy, I can't stop saying that. And so every actions and inactions of political actors must comply with the provisions of the Constitution. The Constitution in Section 109 sub 1 has provided the circumstances in which a member of the House of Assembly would vacate his seat. Subsection 2 of that Section 109 provides that it is the Speaker of the River State House of Assembly that will declare such seat vacant. And in the absence of the Speaker declaring such seat vacant, no other person can declare the seat vacant. The express mention of one thing means the exclusion of the other. That's the constitutional provision. So irrespective of somebody's emotions, nobody should be interpreting the Constitution actually, especially when you have fanciful emotions. You should just look at the spirit and letters of the Constitution and say, okay, what does it say? And the Constitution must be read holistically. I've made this analysis with you when I also did an analysis of Section 103 of the 1979 Constitution. When I said this Section 2 that we have now in the 1999 Constitution is not in the 1979 Constitution. And so if this was obviously happening in 1979, we would say, okay, it's automatic. But we should now ask ourselves one question. Why did the framers of the Constitution include subsection 2? It included it to the extent that it is only the Speaker that can do it. You may not like it, but that's the provision of the Constitution.
Right.
The Constitution creates rights and privileges for everybody. You cannot complain that you who is enjoying the provisions of Chapter 4, your fundamental human rights, you are now complaining about subsection 2 of Section 109. You can't be doing. You can't cherry pick.
I've got to go.
Provisions of the Constitution.
I've got to go. Godspower, Egbule, lawyer, and my guest for.
Let me just correct one impression. Quickly. I am not a politician. But whenever you call me here, I usually want to say,
let me do a legal analysis, share my own legal perspective.
All right, I've got to go. You're not a politician.
I don't know this.
All right,
I don't know this.
All right, I've got to go. Thank you very much. Godspower. My time is up. Commercial break.